I hope you enjoy my stories. Instead of just clicking thumbs down, please comment and share how we can do better. If you do like our video, then please like and subscribe.
So, earlier this month, I purchased a property in real estate lien auction. The property was in a voluntary HOA that had 100% membership. My attorney looked into the situation and drafted a proposal and sent it to the HOA via registered mail. He drafted up a proposal agreement with the HOA with the following conditions. 1. The property owner has unrestricted access to any community-owned roadways, gates, etc. necessary to access his property. 2. This does not constitute joining the HOA. 3. The property owner will pay a figure monthly to the HOA to contribute to the non-government-owned infrastructure at his discretion. The amount is non-negotiable and not legally required, merely an acknowledgement that the assets exist and have costs for their upkeep. 4. The property owner will not be held to any HOA standards. 5. The property owner does not and will not get any voting rights in the HOA. 6. Any further attempts to get the property owner to join will be considered harassment. 7. Cashing of the attached checks constitutes agreeing to these terms. 8. The HOA will provide any necessary access codes for the property owner to use for visitors, contractors, etc. They received it and signed for it. That day, the harassment from the HOA stopped. A week later, their attorney sent back a response. Donacius. The HOA board has met. They do not appreciate your unneighborly attitude and are not agreeing to your terms. However, they acknowledge that your claim to unrestricted access to your property may have legal merit if the issue is taken to court. I have been instructed to give you a gate access code attached below. You will not be given a key fob to the gate as it would give you unrestricted access to their clubhouse. Furthermore, they are notifying you of the following. The roadway and sidewalk are both HOA property, and they reserve the right to remove any illegally parked vehicles or other property. This is, however, a legal acknowledgement that you will not be held to their community standards. They also are requesting some leeway regarding harassment as community notices may inadvertently be delivered. Finally, they are returning the check uncashed. The HOA attorney. I'm not quite understanding how this doesn't constitute them agreeing to my terms, thou. They are giving me everything I want and are turning down my gift towards the upkeep of the road gate. About 25 years ago, my aunt and uncle moved into a new construction single-family home neighborhood on a half-acre. About 6 months after they moved in, he was informed that his neighborhood was being taken over by an HOA. He disregarded his HOA application as he did not wish to join. Not long after this, random neighbors began complaining to him directly about his boat and cars in his driveway violating HOA rules. He just informed the often rude people that he was not a member. They would argue with him that everyone was a member. One of the major issues is that his driveway, garage, and front yard was on the main level of his home, and the backyard dropped down a cliff to level with his basement and backyard. So he had no way to back his boat around the side of the home into the backyard. Eventually, the HOA began harassing him with threats if he didn't move his boat to the backyard. His backyard had been closed off by a vinyl fence the HOA installed and lined another road back there. So one day, my uncle decided to compromise by trying to take down a section of his back fence so he could make a gate for boat parking access. The HOA called the police on him for destruction of property. The police left my uncle with a warning if the fence was returned to proper condition by the end of the day. Uncle put the fence back up and placed his boat back in his front driveway. As the weeks turned into months, the situation escalated with relentless fines accumulating. Each week seemed to bring a new demand, each month a larger sum to pay. The tension reached a breaking point when the fines reached an astronomical $10,000. Faced with what seemed like an insurmountable financial burden, my uncle found himself embroiled in a legal battle with the HOA. In a bold move, the HOA took the matter to court, seeking legal recourse for what they deemed as flagrant violations of the community's regulations. Their case was meticulously prepared, presenting evidence of the HOA's boundaries, which clearly showed my uncle's house situated squarely within its jurisdiction. The HOA representatives detailed the nature of the infractions, citing specific clauses from the community's regulations that had been allegedly breached. Additionally, they highlighted a police report that had been filed regarding an incident involving my uncle's back fence, further bolstering their case.
Undeterred by the formidable opposition, my uncle mounted a robust defense, countering the accusations with a bold assertion of his rights.
He brought forth evidence to support his claim of harassment, citing instances where he felt unfairly targeted by the HOA's enforcement measures. Moreover, he raised a compelling argument regarding access to his backyard, arguing that his property rights were being infringed upon by restrictions imposed by the HOA. As the courtroom drama unfolded, both sides presented their arguments with fervor, each vying for a favorable outcome. The proceedings were fraught with tension as the fate of my uncle's property and his standing within the community hung in the balance. My uncle's defense was rooted in a fundamental principle: he had never willingly consented to be governed by the HOAtions.
He recounted how he had moved into the neighborhood long before the establishment of the HOA, at a time when such regulations did not exist.
When the HOA was formed, he had not volunteered to become a member, nor had he signed any documents indicating his acceptance of its authority.
Moreover, he adamantly asserted that he had never granted permission for his backyard to be enclosed within the confines of the HOA's boundaries.
To support his claims, my uncle meticulously presented a trove of evidence. He produced documentation pertaining to his mortgage, which predated the existence of the HOA, as well as a blank HOA application form bearing the HOA's official stamp and date. This compelling evidence seemed to suggest that, contrary to the HOA's assertions, my uncle had never willingly entered into any agreement with the association.
However, the HOA was unwavering in its stance, arguing that my uncle's failure to submit an application was inconsequential in light of the fact that his property fell within the HOA's designated borders.
According to their interpretation, residency within the HOA's jurisdiction automatically subjected him to its rules and regulations, regardless of his explicit consent or lack thereof. The courtroom atmosphere crackled with tension as these opposing arguments clashed head-on.
On one side stood my uncle, steadfast in his assertion of individual rights and autonomy, while on the other loomed the formidable presence of the HOA, determined to assert its authority over the community. The outcome of this legal battle would not only determine my uncle's fate, but also set a precedent for the delicate balance between individual freedoms and community governance within the neighborhood.
The judge declared my uncle's property was grandfathered as private property and not part of the HOA.
The HOA was to immediately take down their illegal fence on the back border of my uncle's lot.
Since the HOA had fined my uncle $10,000 in illegal fines, my uncle was owed $10,000 in damages for the harassment.
My uncle rebuilt his yard fence in see-through chain link with a gate where he parks all his toys in full view. He moved the boat from the driveway to his front lawn, let the lawn die, and paved it over, all 10 feet from his front door to the sidewalk.
HOA neighbors in the decades since still approach him to complain, and he just tells them to take a walk, knowing there is nothing they can do to him.
In a recent turn of events that has stirred up the community of Mount Garnet, a body corporate overseeing the Pinnacle Village complex has come under fire for its drastic measures against a tenant. The body corporate's decision to disconnect the tenant's electricity and demand a $3,000 bond over allegations of the tenant's son's misconduct has sparked a debate on the extent of power such entities hold and the fairness in their approach to conflict resolution. What is a body corporate? For those unfamiliar with Australian property management, a body corporate is an organisation similar to a homeowners association, HOA, in other countries. Its primary role is to manage the shared spaces of a residential complex, such as stairwells, gardens, roofs, and plumbing systems that serve more than one property. However, it's crucial to note that a body corporate does not have jurisdiction over the private property within the individual units or houses. The situation at Pinnacle Village escalated into a significant controversy when the body corporate took the unusual step of disconnecting a tenant's electricity. This punitive measure was in response to allegations that the tenant's sons had been driving inappropriately on the complex's shared property. In an attempt to prevent further incidents, the body corporate not only cut off the power supply but also demanded a $3,000 bond from the tenant. This bond carried a strict condition. It would be forfeited if the sons engaged in the same behavior again, and the power would not be reconnected. This action by the body corporate was met with widespread criticism, as many viewed it as an overreach of authority and an excessively harsh response to the situation. The imposition of such a substantial financial demand, coupled with the disconnection of an essential service, raised questions about the appropriate measures for enforcing rules within a residential community. The incident has sparked a debate on the rights of tenants versus the powers of a body corporate, highlighting the need for clear guidelines and fair practices in the management of shared living spaces. The recent actions taken by the body corporate at Pinnacle Village have been met with significant criticism from experts in community management and legal professionals. The decision to disconnect a tenant's electricity over allegations of their son's misconduct on common property was deemed absurd by those well versed in the field. This sentiment was echoed by the BCCM adjudicator, who found no legal grounds for the body corporate's actions. The adjudicator's stance was clear. The disconnection of essential services, such as electricity, is a severe and unacceptable response to the alleged bylaw breaches. Consequently, the adjudicator ordered the immediate restoration of the tenant's electricity supply, highlighting the overreach of the body corporate's authority in this matter to the power of 5 to the power of 6. The escalation of the dispute to the BCCM came after the tenant's advocate brought the situation to light, resulting in the tenant's sons being asked to leave the property. In defense of their actions, the body corporate committee presented arguments citing the tenant's responsibility for the behavior of household members and various complaints lodged against them. However, the adjudicator dismissed these defenses, standing firm on the principle that a body corporate cannot unilaterally impose such harsh penalties without a legal basis. The adjudicator's decision serves as a reminder of the limitations of a body corporate's powers and the importance of adhering to legal procedures when enforcing bylaws. The community's response to the actions of the body corporate at Pinnacle Village has been one of strong disapproval and concern. Ross Anderson, an executive from the Unit Owners Association of Queensland, has been particularly vocal, denouncing the decision to disconnect the tenant's electricity and the imposition of a $3,000 bond as absurd. He stressed that such punitive measures fall outside the scope of a body corporate's responsibilities, which are primarily to manage common property and enforce community bylaws in a fair and reasonable manner. Chris Irons, who has a distinguished history as the former head of the BCCM and is now leading Strata Solve, shares this viewpoint. With his extensive background in strata management and dispute resolution, Irons has stated unequivocally that bylaws are not tools for punishment and that committees do not have the authority to exclude members as a form of retribution. His stance reflects a broader consensus within the community management sector that bylaws should be enforced in a way that is consistent with legal standards and community values. The reaction from these experts underscores a fundamental principle in body corporate governance: the need to act within the confines of the law and with respect for the rights of all residents. The situation at Pinnacle Village has highlighted the importance of this principle and has prompted a wider discussion on the limits of a body corporate's power and the appropriate methods for addressing disputes within residential communities. This incident has shed light on the broader implications for residential communities and the governance of shared living spaces. It highlights the need for clear regulations and equitable practices in managing these communities, ensuring that the rights of individual residents are respected and upheld. The Pinnacle Village case serves as a warning, illustrating the potential for overreach by governing bodies and the importance of adhering to legal frameworks when managing residential complexes. The outcome of this dispute may well set a precedent for how similar situations are handled in the future, advocating for a balanced approach that favors dialogue and due process over unilateral punitive actions. The unfolding story at Pinnacle Village is a reminder of the delicate balance between maintaining order in shared living spaces and respecting the rights of individuals. As the community continues to react to the body corporate's controversial measures, the conversation about the role and power of such entities remains at the forefront, with a call for fairness and legal compliance echoing throughout Mount Garnet and beyond. In a detailed examination of the recent dispute at Pinnacle Village, the adjudicator's decision has brought to light significant concerns regarding the actions of the body corporate. Chris Irons, the former Commissioner for Body Corporate and Community Management and the founder of Strata Solve, has been a vocal critic of the body corporate's conduct. Irons, with his extensive experience in the strata sector, emphasizes that body corporates do not have the authority to impose punishments to the power of four. The adjudicator's findings were unequivocal in favor of the tenant, criticizing the body corporate for overstepping its bounds. The decision highlighted that the body corporate had no legal right to disconnect the electricity supply due to an alleged breach of bylaws or to demand a bond or other conditions for the reconnection of services. This ruling underscores the limited scope of a body corporate's powers, which are primarily to maintain, manage, and control common property on behalf of owners, decide on owner contributions, enforce bylaws, and manage body corporate assets. The case has raised broader questions about the understanding and application of body corporate legislation. The adjudicator expressed serious concerns about the Pinnacle Committee's grasp of their responsibilities and powers under the law. The committee's lack of knowledge in this area could have far-reaching implications, not just for the individuals involved but for the governance of community title schemes as a whole. In light of these events, the adjudicator has urged the committee members to educate themselves on their roles and obligations. This call to action is not just for the Pinnacle Village Committee but serves as a reminder to all body corporates to ensure they operate within the legal framework and understand the extent of their authority. The situation at Pinnacle Village is a stark reminder of the importance of legal literacy among those who manage and govern shared living spaces. It highlights the need for clear communication, proper training, and adherence to the legislative guidelines that define the operations of body corporates. As the community moves forward from this incident, the emphasis on education and compliance will be critical in preventing similar disputes in the future.
I would like to thank you for watching the video to the end. To encourage us to make more videos, please like, subscribe, comment, as well as share. Check out this other video if you haven't already.